really wonderful to be hosting this terrific event. And my first and happy task is to introduce the Attorney General of Ontario, the Honourable John Gerretson, and ask him to come up and say a few words.
Thank you. Thank you, Dean Moran, and I know this is a big day for the U of T Law School, as you will be later on today. I understand breaking ground for a major addition to the law school here, so this is a good day for all of us in more ways than one. But thank you very much, and I particularly want to thank Dean Moran for hosting us here today in this wonderful, wonderful setting on this beautiful, beautiful spring day. And of course, I would also like to recognize some of our special guests here today. The Honourable Chief Justice, former Chief Justice Roy McMurtry, Justice of the Supreme Court of Canada, Frank Iacobucci, and the Associate Chief Justice for Ontario, Coulter Osborne, as well as my colleague here, Yasser Naqvi, the Minister of Labour, and a member from Ottawa Centre. There are a number of other people in this room as well that I hope to be able to say a few words about as we continue on. Our government is committed to building a fair and democratic society where everyone has the opportunity to participate in and benefit from Ontario's prosperity and our good quality of life. And we know that a democratic society is stronger when citizens are free and empowered to participate in it, and when they have access to the services and support that make these contributions possible. Most of you in this room know better than anyone that a citizen's confidence in their justice system and their willingness and ability to participate in a democratic society are inextricably linked. Ontario has a high-quality system of justice with a good court system, but it's not perfect. There's no question that litigation is expensive and matters can take at times a long time to be resolved. And that's why I'm so pleased to have all of you here today as our government gets ready to break new ground of our own with the introduction of the Protection of Public Participation Act. Now, strategic lawsuits in Ontario are relatively new, but we know firsthand the chilling effect they can have on public debate. To respond to these suits, 3 years ago, my predecessor, Chris Bentley, convened an expert panel to study the issue and recommend the most effective way to address them. And the panel was chaired by Dean Moran and included prominent lawyers Brian McLeod-Rogers and Peter Down. And both these gentlemen are here today, and I thank you for being here today as well. And I'd also like to thank you for your hard work and the excellent report that you prepared and presented at that time. After extensive public consultation, the panel produced a report which is reflected in the bill that I will be presenting to the legislature this afternoon. Now let me just say a few words about the bill without revealing the entire bill, because I don't want to be held in contempt of the legislature. It is a bill that would, as its name suggests, help protect the freedom of everyday Ontarians to voice their opinions and participate in open debate on matters of public interest. This Made in Ontario solution, based on the report from the expert panel, will help balance the protection of public participation and freedom of expression with the protection of reputation and economic interest. Now, the centerpiece of the proposal is a fast-track review process for lawsuits alleged to be strategic in nature. The legislation provides that a party that believes that has been sued in a strategic lawsuit can file a motion to have the suit dismissed. And within 60 days, a legal test would be used to determine whether or not the suit is abusive or should be allowed to proceed. In applying the test, the courts would seek to balance the interests at stake, with an eye not only on the technical merits of the plaintiff's case, but also the value of free expression on matters of public interest. where the plaintiff is likely to suffer serious harm, the case would be allowed to continue. If, however, there's little or no harm likely, then the technical merits of the case would yield to the value of public democratic debate, and the suit would be dismissed. Now, this change would help good parties with different resources on a more equal footing. The bill that will be presented today supports some of our most cherished values as citizens of this great province, and strikes an important balance of interests of both plaintiff and defendants in defamation suits. The ability to freely participate in public discussion about matters of public interest without fear of retribution is a hallmark of a fair and democratic society. It is a defining feature of our province that I know we all agree is well worth defending. So thank you very much for attending. I'd also like to recognize at this time Tom Marshall, who I know that I believe he said it was 7 years ago today, actually 6 years ago today, when this issue was first studied by Tom and his group. And I would also like to recognize the tremendous work done on this bill by John Gregory, the General Counsel of the Justice Policy Branch of the Ministry of the Attorney General. Where's John? He is the brains behind this. And he's been ably assisted by Andrea Strom and the entire legal team there. So now I would like to call upon Dean Moran to share her thoughts on this landmark piece of legislation and the important role that she and the other panel members have played in getting us to where we are today. Dean Moran.
Well, what I would like to do is just say a couple of words on behalf of not only myself, of course, but my wonderful co-panelists, Brian Rogers and Peter Downard, and as you said, Mr. Attorney, the fantastic work done by the staff in the Ministry of the Attorney General. So when Attorney General Bentley gave us our mandate, what he asked us was whether Ontario should have legislation of this kind. And in order to consider that question, what we did was we engaged in a process of consultation, widespread public consultation. We had a number of different manners in which people could provide their input, and we had over 30 different groups come and speak to us about their concerns and their thoughts about the legislation. We also did very extensive research, and that was actually, again, back to the wonderful work done by the Ministry of the Attorney General on other jurisdictions, because there's actually a lot of other jurisdictions that have considered legislation and looked at legislation in this regard. And the result of all of that work, the consultations and the research, led the panel to answer Attorney General Bentley's question, should we have legislation, with an unequivocal yes. There was simply no doubt that in order to support some really fundamental values in this province and in democracy, we all felt that it was very important to introduce legislation. We heard that from the stakeholders, and they were many, many different groups: Ontario Bar Association, environmental groups, individual citizens, and we also saw that from a number of other jurisdictions as well. But we also felt it was important to consider, we looked at a lot of other models, none of them fit perfectly, and so we wrestled with how to try to come up with a balance between the incredibly important value of citizens being able to engage in the democratic process without fear of retribution. And also, I think very, very important, which you mentioned as well, the consumption of judicial and court resources on cases that really lack legal merit was another very significant concern. So we looked at that on one side, and then of course on the other side, individual citizens and others have a right to protection of their reputation. So how do you come up with a solution that balances those two very, very important interests. And so while I don't know the details of the legislation, I can say on behalf of my two wonderful co-panelists who are great lawyers and really deserve much more credit than I do on this, I know that collectively we're really delighted, and we think it's going to be a very important step forward for democracy and for access to justice in this province, and will place Ontario at the forefront of jurisdictions dealing with what are very challenging problems. Thank you very much.
Thank you very much, Dean Moran, and good luck with the rest of the day's activities here. I'd also like to thank the Ontario Bar Association and all the various members of various committees that have been working on this issue as well. Now, before closing off and asking if the media has any questions, which they may have, sometimes they do, sometimes they don't, I would like to take the opportunity to thank the Honourable Yasanaki for being here. Over the years, there have been a number of private members' bills presented in the legislature with the same effect, and Yasser was the last to do this a year or so ago, and I would ask him just to ask him if he wanted to say a few words at this time. Yasser.
Thank you very much, Minister Gerretson. This is a very important day for Ontario. Perhaps on a surface it may seem like that this is an issue which lawyers and legal experts may only get excited about. But we know, as we heard earlier, that freedom of expression and speech is the foundation of our democracy. Our society is stronger if citizens and community groups are able to engage in issues that are of public interest. An issue that has often come up in my community back in Ottawa, and that is why last October I tabled a private member's bill putting in place the recommendations that were made by the expert panel. And I want to thank the expert panel for their guidance in showing the path as to how we can have a made in Ontario model of protecting public participation. I also want to thank the Attorney General and his office and staff for indulging me and taking many phone calls and meetings from me and speaking on my community's behalf as to why this issue is important. I had the great fortune of working with some really important stakeholders. Many of them are in this room in getting that bill forward. And I strongly feel, as I think all of us in this room, that with the introduction of this bill and hopefully with the passage of this bill into law, our democracy in Ontario is going to be stronger. So once again, Attorney General, thank you very much for your leadership on this very important issue and continue to build a more democratic and fair society in Ontario. Thank you.
And let me just say that on behalf of Yasser and myself, and although we are graduates of Queen's University in Ottawa, it's great to be here at the U of T Law School. Now, are there any questions that the media or anyone else may have at this stage?
Sir, the report was submitted in 2010. Why has it taken 2.5 years for the president to introduce this legislation?
Well, it's an issue that has been around for a long period of time. As a matter of fact, I was first made aware of it in a real sense when I was Minister of Municipal Affairs and Housing, and that's almost 8 or 9 years ago. It's taken a lot of work. I think that the John Gregory and his staff have worked extremely hard on it, and I think it's fair to say that we've reached the stage now where we think that legislation is required in that regard. One can always say, well, why didn't you do it earlier? The reality is we're doing it now. The only other province that has legislation somewhat similar to this is Quebec, which of course has a different system of justice. But we think that this Made in Ontario solution is the right way to go. They had a similar act like this, which was much more prescriptive in British Columbia, and basically they withdrew the law after a very short period of time. We felt that this was the right time to deal with this, but I suppose we can all have our opinions to why it shouldn't have been done earlier. But there's always a right and a good time. This is the time to do it.
Would this also apply to the employment?
Yes, without getting into too much detail, there are going to be provisions in the Act that deals with administrative tribunals as well.
So, Minister, you're introducing this afternoon, the House could rise Thursday, and we could have an election in the fall. Is there, I mean, what's the timetable like for this to actually happen? And as to Maria's point, it's been many years since Attorney General Bentley instructed.
Well, I think it's fair to say that if the House does rise on Thursday, it probably will not be given second reading before the summer recess. I expect that to happen sometime early in the fall. I would hope that the parties in the legislature will allow the minority government to work on, for the foreseeable future. I think is what the people of Ontario want. So that I would anticipate the second reading will be given sometime this fall, then it will go to committee, and hopefully it could be in place by the end of the year.
Have you had discussions with the other two parties about this?
I know that certainly the New Democratic Party has great interest in this as well, and we have reached out to them, and from comments, just general comments that we've had from various members, they seem to be very much interested in this kind of an approach as well. Wow, this is a lot more restful than most of the scrums. So with that, thank you all very much for coming. I know that all of you are very much interested in this. I would like to thank all of the people that have been involved in one way or another in making it this far in this process. A bill will be introduced in the legislature this afternoon around 3 o'clock, and if any of you are interested in being there, I'm sure that my staff can provide the necessary admission slips to the gallery, the members' gallery. Thank you very much for being here this morning. Have a great day.